Thank you so much for joining us today to the Law Society of Nunavut's Lunch and Learn on demystifying civil registry filing and chamber dates. I had to read that from my little note here to make sure that I said it correctly. My name is Stenate Vandenberg. I am a policy and programs coordinator with the Law Society of Nunavut. I will be facilitating this discussion today. We welcome Clare Cudmore, who will be introducing herself, and we are going to get started right away. I just want to give two things of housekeeping. This will be recorded, so please just make note of the fact that this will be recorded and it will be made available on our website as soon as possible so that other people can also are also able to see it. And then we will also update the website once we make the recording available with the amount of time that this will count towards CLE activities for this year. So without further ado, welcome, Clare. Thank you.
Hi, everyone. My name is Clare Cudmore. I'm I just have to check to make sure I wasn't muted because that's a meeting thing, right? Where you talk for a few minutes and then realize that you're muted. My name is Clare Cudmore. I'm the Executive Officer for Court Administration at the Nunavut Court of Justice. I'm so excited that so many of you have the opportunity to join. We are here today to talk about some of the procedural requirements for filing documents with the Nunavut court registries, and to also review some handy dandy tip sheets that the registry has prepared to help demystify navigating the filing process in Nunavut, but also to help navigate some of the procedural requirements for both seeking and maintaining chambers dates for both regular civil chambers and special chambers with the court. So a little bit of history about the project. The civil registry has been navigating having to return some documents for counsel. And one of the realities of practicing in Nunavut is that there's a lot of requirements that are specific procedurally to the court in Nunavut. And as we know, the rules of civil procedure in Nunavut have been around a while, and the court has introduced additional requirements through a plethora of practice directives that are available on the court's website. And so in order to provide some helpful information that will assist counsel with filing documents correctly with the court, we have compiled two separate tip sheets that we hope are easy to use and informative. And my intention today is to go through those tip sheets and perhaps take any questions or clarifications from the members that are on the line. So if you bear with me, I'm just going to share my screen here to go through the documents. There we go. So you should be able to see my screen now. Now these PDFs were available on the Law Society's website for download as part of the materials for the CLE, but also these are available by request through the civil registry at any time if you lose track of the documents in your email. But you will see that these tip sheets don't intend to address all of the issues or all of the requirements for filing, but they really do break down the issues with documents that the civil registry sees on a more regular basis. And so, for example, if you look at the top left in the blue square, one of the things that we do see quite regularly is lawyers trying to file documents without the filing request form. And as counsel know, there are legislative fees that are applicable to some of the documents that are filed with the court. And in order for the registry to be able to calculate those fees, we need you to send the required filing request form. Now, one of the things that we hope is helpful about this tip sheet is if you are looking at it in PDF, you can actually click, there are links that will open that will take you to the appropriate locations on the court's website. And just to confirm, these documents are available in English, French, Inuktitut, and Inuit-Acton. If you would like to request copies, each of those languages are linked on the Law Society of Nunavut webpage. One of the other things that was coming up quite often was issues with both the form and style of cause of documents that lawyers were trying to file. From time to time, we do see lawyers who practice in other jurisdictions filing documents in forms with the style of cause for the other court, for example. And one of the things that we have tried to do is provide information about the specific rules that set out the requirements in Nunavut. And again, if you click on the rule, it will take you to the part of the court's website that has our rules of court available. And so we have some information and then hints and tips for counsel to consider when reviewing the document. So for example, one of the things that can be challenging for the registry when filing documents is if there is a interlocutory motion filed, for example, where a plaintiff becomes a moving party and a defendant becomes a responding party. So there's a hint here to remember to reflect on the style of cause, which party is which for the purposes of the application that you are filing. And here's a big one that the Law Society would be of interest in. You will recall that the rules in Nunavut actually require that documents are filed by lawyers who are authorized to practice law in the territory. So if it is not a party to the proceeding, documents must be filed by a lawyer who is authorized to practice law. And so we have linked to the rule in the rules of court that require that, but also flagged that there is a practice directive that sets out certain requirements, because we understand that particularly when you're coming from other jurisdictions, perhaps you may not be aware that the court has particular practice directives, and there is a volume of them that can be challenging to navigate by times. And so we have tried to flag both the applicable rules and the applicable practice directive that would be relevant. And again, you can click on the link and review the practice directive in its entirety. These are meant to be, again, quick tips and snappers that help refer you to the appropriate information. So for example, perhaps you did not know that Rule 732 of the Rules of Court, which is, I don't know if you can see my mouse, I'm circling it, it's in the green box, but there's certain mandatory information that's required on pleadings. Also, fun fact, Rule 731 of the Rules of Court, which is not on this tip sheet because it's not something that comes up very often, but Rule 731 requires that documents be filed single-sided. And so if documents are printed on both sides of the page, that's not actually acceptable in Nunavut under the rules of court. And so we hope to be able to flag these issues before you send your documents in so that there's no delay or a requirement for a little bit of additional work. And so, things that you can check and double check before you are filing your documents. And you may see going forward, if you file a document that has a challenge that may prevent the registry from being able to accept it as presented, the clerks will actually refer you to this document for help. And so if you get this tip sheet back with your documents, that's a fairly good indication that you should go through the tip sheet and the hint and double check your documents to make sure that you haven't inadvertently filed something that doesn't comply with the rules. Now, two more big ticket items that sometimes will see you get documents returned are both signatures on documents that you are filing, but also the witnessing of signatures. And so when we're talking about the signature on the document that you're filing, it's important to remember that Rule 15 of the Nunavut Rules of Court require that documents are signed. The Nunavut Court of Justice does not accept electronic signatures. And so I know, for example, that Adobe PDF has a secure signature feature on some PDFs, but a document would not be considered signed if you tried to sign it using the secure PDF signature feature. That also, for the record, means that digital copies of your signature are not acceptable. You have to sign the document and then scan it in accordance with Practice Directive 18 or Practice Directive 31, depending on what you're signing and why. So that's a big hint that often results in documents being returned. Another frequent issue that the registry sees is in relation to the witnessing of signatures. Now, to flag, as it does here, Rule 368 of the Rules of Court actually require that the person who is swearing or affirming the signature, so if you have a notary or a commissioner, or you're signing as a notary or commissioner, the rules require that the person witnessing the document print their name under the signature. And that's something that is often missed. And that's an important feature, because you have to be able to identify the commissioner or the notary, which is often difficult. As we know, many lawyers could have been doctors in terms of the quality of their handwriting and signatures. And so please make sure that when you are requesting documents to be commissioned or notarized, you are confirming that requirement if your client is taking the document to someone other than you. Also, tip, the Evidence Act sets out requirements for commissioning of oaths signed within and outside the territory. The registry often sees documents filed from other provinces that are signed by commissioners rather than notaries, and those documents will be returned. You'll also see that there was an exception made during the pandemic about witnessing via video conferencing, and those exceptions no longer apply. So documents must be witnessed in person. So when you are going through before filing your documents, please make sure that the person who is signing the witnessing the signature is properly authorized in accordance with the Evidence Act. And again, please make sure that they print their name legibly under the signature in accordance with Rule 368. The other thing that is often gets flagged, please don't forget to make sure that all of the exhibits to an affidavit are endorsed by the notary or the commissioner, because the registry from time to time has to send affidavits back because they are not, all of the document is not properly witnessed or endorsed by the commissioner or the notary. Another thing that comes up from time to time is in relation to service. We often get questions about the requirement for an address for service in Nunavut, and fun tip, it is actually the definition of the address for service in Rule 1 of the Rules of Court that require that the address for service be in Nunavut. And so this means that every party to the proceeding must provide an address for service within the territory. And so that is something that the registry checks. So please make sure that you include the address for service, which is a requirement under Rule 15. We have also flagged, just so that council doesn't miss it, the court has a whole practice directive 31, about the requirements for the electronic service of documents. There's no hints or tips in relation to that one, but just as a heads up, Practice Directive 31 is a good read and something to keep in mind if you are serving documents via email. And finally, in relation to documents that are filed with the registry, the court does require that documents have a back sheet, which is sometimes referred to as a backer. And the form for that backer is set out in Form 1 of the rules. And so when you are filing documents, please make sure that you have attached the backer to your document, and that includes your style of cause, your court file number, and the correct short title for your document. And please make sure that that is at, not to be funny in a way that I think that I'm funny and perhaps I'm not, please make sure it's at the back. We often, the registry often receives documents where the backer for the affidavit is at the end of the text of the affidavit and doesn't follow the exhibits. And so please make sure that it's the last page of the document. So those are the quick snappers of issues that come up with a certain amount of regularity with documents that are being filed with the registry. Again, it's not a comprehensive review of the rules of civil procedure, although I do love chatting civil procedure. And if it is of interest to you, there are some working groups happening with the Civil Rules Committee, because we're hoping to update the rules as they have not been updated in quite some time. But I don't know if anybody has any specific questions about the filing tip document, or if I should just move on to the Civil Chamber States document. I'm gonna stop the share for a second to see if there's any hands. I don't see anybody. Okay, so I'm going to share the Civil Chamber States document. So you will see that the formatting of this document is very similar to the filing tips document. And again, this is hoping to flag. Sorry, Anne, did you have a question? For sure. Did you want to unmute, perhaps? I don't know that we can hear you.
Good.
Yes.
Good morning, I guess. Good afternoon. So we're just discussing electronic signatures, and we're looking at PD18, and PD18 seems to authorize electronic signatures.
So through our discussions with the court, it's allowing the document to be scanned and sent, signed, and then scanned and sent electronically.
Both.
So the PD references both. You want to read out what it says?
Yeah, it says the solicitor shall provide either an electronic signature or scan his or her signature into the document.
Okay, I'll have to raise that with Chambers, because when we were preparing the documents, we did so on their direction, but certainly I can clarify that.
Okay. Thank you.
No problem.
Okay, we're good. Yeah.
Were there any other questions? And certainly I can flag that one of the hope and intention in terms of the review of the civil rules is to try and modernize and make practices more accessible, and certainly electronic processes are a hot topic.
I've got a question on affidavits, which is the as opposed to a commissioner.
Sorry, Anne,
Like
you
muted again.
cut out there for a second. No, I think there was just a bit of a lag, so I apologize. I didn't hear some of what you said.
Okay, so there's a standing requirement that out of territory affidavits require notarizing rather than commissioning. But it just seems like things get filed anyway, and I'm some old fogey who's insisting on these rules. Are we just accepting commissioning on all documents, or is this going to be the standard? One hates to be upholding something that nobody else seems to be concerned about.
You will find that going forward, that one of the things that the civil registry is going to be checking is whether or not the documents are properly sworn in accordance with the Evidence Act. And so while it may be the case that perhaps there wasn't scrutiny in that regard, there will be a verification as to whether or not the person who is swearing or affirming the document, at least on the face of the document, appears to be properly qualified in accordance with the Evidence Act. Sorry, Anne, you're muted again. I don't know if you've...
I had no response. I was listening to yours.
Okay.
Okay, that's good. Typically, lawyers are commissioners, so we're good inside the territory. I don't know as many are notaries because it's a separate registration.
Actually, with the Evidence Act, a lawyer who is authorized to practice in Nunavut can notarize documents even outside the territory. If you review, my apologies, I think it's section 52, but I don't have it directly in front of me. If you are in active practice in Nunavut, there is a process to follow where lawyers can actually commission documents outside the territory. But it is the only exception.
I will take a look at that. Thank you.
No problem. It's a very interesting.
I know the one that says your commission, your authorization doesn't expire, like you don't have to renew it.
Mm-hmm.
But I'll take a look.
For sure. Unless there were any other questions about filing, we'll flip over to the civil chambers dates. Awesome. So again, this document is intended to be a quick and easy reference for the council who are trying to navigate both the requirements and the rules and some requirements set out by the practice directives. It also helps flag issues where from time to time the civil registry has seen challenges with dates being maintained because of trying to navigate some of the procedural requirements. And so you will see, for example, in the section that talks about regular chambers versus special chambers, we have put a handy link to where you can find the NCJ court schedule to find out when civil matters are and when the regular civil chambers dates that occur at the NCJ and in the communities. So the document clarifies both the time of the regular civil chambers dates, but also flags that the court actually has a practice directive that provides guidance to where you should be requesting your matters be set. So if it is in a community or at the Nunavut Justice Center, we also have flagged Rule 387 that establishes the requirement for civil special chambers dates. So if your matter is going to be taking more than 30 minutes, that's deemed to be a special chambers requirement. And the rules also require that particular matters proceed in special chambers. And we also flag that special chambers matters are subject to court availability. And as I'm certain all of you know, there is a practice directive 33, that requires counsel to coordinate with the NCJ trial coordinator on seeking special chambers dates. And so in terms of when you're filing documents and requesting dates, the hint is to please make sure that you've turned your mind to whether or not this is what you're requesting a date for is a regular chambers matter or a special chambers matter. And if you are requesting a date in regular chambers, please review the court schedule to determine the date and location and put that time on your notice, also flagging that there is a process under Practice Directive 33 to request a date. And we flag this because, as council may have experienced or may have seen, sometimes matters can be delayed because council try to file them in regular civil chambers, and then it becomes apparent that the matter is going to take longer than the allotted 30 minutes, and then the matter has to be adjourned from the regular civil chamber state, and then council has to check for a special chambers date. There are also particular practice directives about the requirements for the service of documents for chambers. And so this tip sheet tries to helpfully flag to review Practice Directive 16 for the requirements for proof of service, and the requirement that it must be filed at least three clear business days before the chambers date, or your matter will be struck from the docket by the court registry. And so, our hint is to make sure that you note on your calendar that your requirements for filing and serving, and try and do that at least 4 business days before, so you've got a bit of a buffer. And so, we have also flagged that there is a difference in the requirements for filing deadlines for circuit matters. So if you have a civil matter that is proceeding on a circuit, Practice Directive 15 actually sets particular requirements. And remember, when the court is traveling on a circuit, the court actually departs to go to the community prior to the circuit. And so if you review the Practice Directive, there is a process in the Practice Directive if you are going to be late in filing. And so please make sure that you review that directive and that you are in communication with the registry if there may be challenges, because if you file the documents after the court party leaves, it is not as helpful as one would hope to get the documents before the court. If we can move to the orange part of the document, you will also see that we have flagged that Rule 390 of the Rules of Court require that council must file and serve on all parties a memorandum and list of statutes and authorities, including case law, referenced in your application before the chambers date. And that rule actually interacts with Practice Directive 17, which states that you actually have to file that three clear business days before the chambers date, or your matter will be struck by the registry. And so again, just a hint to make sure that you are tracking those the timing of those requirements in your calendar. Because again, if the memorandum that's required is not filed, you run the risk of losing your date. If you move over to the teal, is it teal? I don't know. The lighter blue on the right, you will see that there are also specific requirements for attending by phone or video conference. And so for regular civil chambers, you will see that Practice Directive 4 requires that if you wish to attend a regular civil chambers appearance that does not include witness testimony, you have to file your Form 4A no later than 3 clear business days before the appearance. And you will see in reviewing Practice Directive 4 that there are specific requirements for special chambers. So those appearances that are longer than 30 minutes, or where there might be viva voce evidence from witnesses, you actually are required to attend in person, where parties may call witnesses to testify, and you actually have to seek leave if you want to attend by telephone or video conference. And this is a big issue that happens where we see chambers dates or special chambers dates fall apart. And so, you know, big hint and tip, please make sure that in the event that you expect to appear by telephone and it is a special chambers matter, or or a witness is going to be appearing, or witnesses are going to be testifying, you must seek leave to do so before the civil chambers appearance. And so to meet the timelines of not having your matter struck, that leave has to be sought before 3 clear days before the appearance. Otherwise, if you're not attending, your matter is going to, and you don't have leave, your matter is going to have some difficulty proceeding. So if you want to like highlight that one, that's a big reason why the registry sees chambers dates collapse. So if you have a matter struck from the court schedule, in the red box here, we wanted to flag there is a process. If you have a chambers date and you need it to be adjourned or you're not prepared to proceed, there are forms that coincide with the practice directive requesting to have your matter rescheduled. And so, but you must file those in accordance with the practice directive. And so if you have a regular chambers date that ends up being struck because you did not file your 34, your motion confirmation or your request to adjourn, and your matter gets struck, you must file and serve a new notice of motion or appropriate originating notice. Or if it is a special chambers appearance, you have to work with the trial coordinator on a new 33A. And so, you know, important to keep track of those timelines for filing, because getting your matter struck is it creates more work for you to reseek the date. Now, here is a what we hope is a helpful hint. You're only required to reserve the new notice of motion. So if there are other documents like affidavits and things that were previously served and filed, you do not need to reserve those. So just you do have to reserve the notice of motion or the originating notice seeking the date and the notice to the witnesses. And we've just addressed rescheduling a matter. Perhaps we should have addressed the pink first of confirming that your matter can proceed. Sorry, all of your Zoom faces are over that portion of my document. So we have gone through the process under the practice directives for confirming your dates once you have filed them. And so you will see that this flags, and again, helpfully links to the portions of the court's website where you can find all of the practice directives and the procedural requirements and the rules. But one of the biggest reasons why civil chambers matters don't proceed is because counsel don't file the appropriate confirmation documents in time. And so, you know, if as part of your practice, you can start flagging these timelines, it will generally make less work for you in the longer term. But you are required to file a 32A no later than 2 clear business days in advance of the scheduled date. And you will note at the bottom of the document, we have confirmed the filing hours of the registry. And so we can I just want to make sure that counsel are aware that the requirements and the filing requirements, you must do so within the appropriate filing hours of the registry. And so we are hoping that centralizing all of this information in a colorful and hyperlinked way might make it a little bit easier to navigate and confirm the timelines. We are hoping that it might be helpful prior to filing documents or when you are requesting motion dates to review the tip sheet somewhat like a little bit of a checklist, because the more that documents are received correctly and on time, and that motions are confirmed, or that, for example, leave is sought for remote appearances in advance of a special chambers date or a trial, the more successful we are in using court time effectively. So that is the chambers dates tip sheets. Again, it's not intended to be an exhaustive list of all of the requirements in the rules, but these are the kind of hot ticket items that come up where the registry sees with more regularity. These are reasons why dates are lost or not secured. Does anybody have any questions about chambers dates? Hey, Ted.
Sorry, I don't know. Can you hear me okay?
Yes.
Okay, I'm looking at your orange box, the one about memorandum of authorities.
Yep.
Rule 390 says 48 hours, not 3 days. And to clarify, I think Practice Directive 17 says 3 clear business days for chambers being held outside of Iqaluit, not in Iqaluit.
Right. Okay. I'll have to confirm that. Again, I'll have to go against it. But if I will certainly update it. Sorry.
I was going to move on to a different colored box. So if I look at the blue box, the Practice Directive 4, wishing to end civil chambers, filing a 4A.
Yep.
Is this going to be kind of a compulsory new element of things? Because I don't think I've ever filed a 4A for me attending court by phone.
So the practice directive currently requires it. I believe that Ted, that there is a convention that for council who are resident in the communities, that we don't strictly enforce the form 4, but.
Okay, so could I still rely on the convention? It's just another form we have to fill out a day before, and just as a comment, it would make sense if we're going to have to file that form to file it at the same time as the confirmation.
That's fair.
It just neatens things up for the court staff.
I am aware, Ted, that Practice Directive 4 is currently being reviewed to try and make it a little bit more easily understood, and I will certainly make a note of the helpful suggestion for civil matters to file it with your motion confirmation.
Thank you.
No problem. Were there any other questions? Okay, so I mean, ultimately, what the intent of these documents are is to try and encourage. Okay, and if you just want to unmute, you can ask away.
Okay. When there's a special chambers date set, we have not been submitting motion confirmations. I mean, it seems pretty obvious at that point, council are all on board. Nothing's going to fall by the wayside.
So it's my understanding, Anne, that the that the registry has been directed to follow, but I can certainly look into that and then clarify.
I mean, my understanding is it's to prevent these applications that keep flipping over from regular date to regular date without resolution. In a special date, everybody's picked the date, you've submitted, whatever. If you're not going to proceed, I think you better tell somebody you're not proceeding.
It's totally fair.
And the practice has been not to file the confirmations. So I'm hoping that we'll be able to continue that.
I will certainly do some investigation of that issue. I mean, and when there's a special chamber set, there's so much communication between the trial coordinator, chambers, and council. I think that the mischief, I think that you're correct, that the mischief that we're trying to avoid more relates to the ongoing turnover with regular chambers dates and the requirements for service and things like that. Again, the stickiest wicket that the registry and the court has seen in relation to special chambers involves that the application of practice directive 4 and remote appearances where there's viva voce evidence in special chambers matters. And so, but I will certainly clarify that. And it is also something that we can kind of flag for consideration when, if and when the rules get reviewed and things like that. But that's a good point.
I guess my concern is, can I safely continue? Because I've never been asked for motion confirmation for special chambers. I really don't want to start. It really is just more paper. So I'm hoping that unless we get a notice of some kind, we'll just be able to.
I can certainly I can't make blanket commitments without consulting with the court about it and like taking a deeper dive into the issue. But certainly I will, if there is going to be a strict requirement about motion confirmations on in relation to practice directive 33, I'll make sure that there's an email sent around on Monday, if that's helpful. And if you don't get an email, we'll assume that your regular practice can continue. Is that fair?
Hope so.
Okay. Were there any other questions? Okay, well, thank you so much, everybody, for coming and for using the tip sheets and keeping copies handy and near you when you are filing documents and requesting dates. Our hope is that with this more helpful and centralized information, that things will run a little bit more smoothly in terms of when documents are received and then quickly reviewed, confirmed, and filed, and that chambers dates will be confirmed without issue going forward. So, and if anybody has any particular issues, or if there are other kind of ideas that you have for tip sheets that might make practice a little easier, please feel free to send me an email. I would be happy to chat about what information can be prepared to assist.
Thank you so much, Claire. Just to confirm the details that you will be looking into, will you share that with us, and then we can share it to everyone who has participated today? Perfect. So once I get that information, I will be sure to send out an email to everyone who is here today. Thank you so much for taking the time to be here, everyone, to Claire for being here and facilitating this lunch and learn for us. We look forward to seeing you next time, and I wish you all a wonderful weekend.
Bye all. Thanks, guys.
Thank you.